wrote petitions and criminal cases.
So far
have
from
made various
yesterday,
pronouncements on the issue of murder and the death penalty.
You know, this event
they grappled with the issue whether the death penalty should remain as a sentence under our penal laws.
We are very happy that
some of these cases were
the ones who ran last year,
Godo, Motiso, and
the champions who ran last year,
Republic,
like in Barsoton.
and then Joseph,
they are back
Juguna,
again this year.
Maura, and two others
So we are
versus
very happy.
the
So
Republic.
the criteria really is,
Court of Appeal
and I think General is going to elaborate.
The decision of the three-judge bench in Godfrey Ngodo Motiso was declared per incuriam by the five-judge bench.
Part of the
in the case of Joseph Njogona Maura and two others was the Republic, insofar as it purported to grant discretion to courts in the exercise of sentencing persons faced with murder charges.
To the seniors.
So the issue of the death penalty,
so I don't think
constitutionality and application under the new constitutional dispensation is now settled. The binding judgment of the Supreme Court in Francis Kariuko, Moroteto, and another versus Republic, where the court made the following order, that is Order G, paragraph 112 of the judgment.
And we have over 35.
They say that accordingly, with regards to the claims of the petitioners in this case, the court makes the following orders. A, the mandatory nature of the death sentence as provided for under Section 204 of the Penal Code is hereby declared unconstitutional. For the avoidance of doubt, this order does not disturb the validity of the death sentence as contemplated under Article 26(3) of the Constitution. Now, prior to making that order, the Supreme Court made the following guidelines,
and is individualized,
and I quote,
and so if every event
as a consequence of this decision, paragraph 6.4 to 6.7 of the guidelines, that is the sentencing policy guidelines of the judiciary, are no longer applicable. To avoid a lacuna, the following guidelines with regard to mitigating factors are applicable in a rehearing sentence for the conviction of a murder charge. Now, A, age of the offender, B, being a first offender, C, whether the offender pleaded guilty, D, character and record of the offender,
as much as they have got numbers,
C,
and they have got and they have got chips. It can also create a little bit of a problem. So we are not restricting, but I think it is not also good to have
E, commission of the offense in response to gender-based violence.
Okay, thank you very much.
F, remorsefulness of the offender. G, the possibility of reform and social readaptation of the offender. And then H, any other factor that the court considers relevant. We wish to make it very clear that these guidelines in no way replace judicial discretion. They are advisory and not mandatory. They are geared to promoting consistency and transparency in sentencing hearings. They are also aimed at promoting public understanding of the sentencing process. This notwithstanding, we are obligated to point out here that paragraph 25 of the 2016 Judicial Sentencing Guidelines states as follows. That is a quote, guideline judgments, where there are guideline judgments, that is decisions from the superior courts on a sentencing principle, the subordinate courts are bound by it. It is the duty of the court to keep abreast with the guideline judgments pronounced. Equally, it is the duty of the prosecutor and defense counsel to inform the court of existing guideline judgments on an issue before it. Now, the circumstances of the offense. In respect of the first accused, the evidence that is before this court was proof that the murder of the deceased was premeditated and that it had been hatched by the first accused was the master plan several days before the date of the execution of the plot.
At Nyayo National Stadium in 2010. And then the next one was
the conspiracy involved high-level planning and organization, meticulously carried out. It involved sophistication and the use of technology with mobile phones and police radios. On the material morning, the victims' movements were monitored in and around the courtroom at Mavoko Low Court. Eventually, they were trailed abducted and buried in the abductor's vehicle. That is a private car to a container.
And actually we did it.
At Syokimau AP Post, they were locked up at midday and detained until nightfall without food or water. From the circumstances of the offense of the case, the following are the aggravating circumstances or factors.
During the Doha World Championships,
one, the murder was intended to interfere with the course of justice. Two, the offense was committed by a group.
Host an international event.
Three, the deceased were kept inside the boot of a car and taken out one at a time to be murdered. The murder was executed close by so that the victims could hear the thumping and blows being inflicted and the screams and shouts or groans of their colleagues.
Because you know,
as he was killed,
the World Championship last year was in Oregon, in the United States of America.
They would be the next to face the same fate.
In Europe.
Must have caused
so we wanted to do
them extreme fear,
because it has never
stress,
been done
and psychological torture. That
so
is
we wanted to be the
victims
first one to
as
do
they
that.
waited
So
for their time.
we applied.
Now, four,
and we were
crude weapon was used to batter the victims,
go through the process. There's a long process. You are going to feel a lot of
to the victims.
You have got
Five,
to check
the
and
disease
find
were
out,
put
you know,
in
the
gunny
capacity
bags
that you have and so forth.
and plastic bags
we did
and
all
dumped
that.
into the river
and
with the
there were quite a number
intention
of
to
countries that had
conceal the
applied.
murders and make the recovery of their bodies
eventually,
difficult.
when the panel sat, because World Athletics formed
the murder involved flagrant and excessive use of violence on the deceased and caused damage, of course, to their persons.
And that was
Seven,
Poland,
the first accused,
Singapore,
while he
Japan,
clearly had a grudge against the deceased
so we were one of the,
he captured and killed the deceased Kimani and the deceased Mogori, not caring about their lives and the fact that they had not done anything to him to deserve what he did to them.
The capacity,
they were collateral damage, and I must add that not that Mwenda deserved the judgment that he received,
and we took them through
from them either.
All the facilities
now,
that
the first accused being a police officer who had been employed and paid a salary with public funds to protect life and preserve property, acted in flagrant abuse of his office and acted contrary to the duties and responsibilities he was employed for.
Unfortunately, we lost
and also the offense involved detention and
inhuman
treatment
is that
of the
we
deceased
don't
persons.
have the proper infrastructure.
Now, the issue of culpability, the first accused shot the deceased Mwenda 1 year before the incident, which is the subject matter of this case, even though the injury was very severe, being a gunshot wound that involved the hand and the upper chest. The first accused, after taking him to a clinic for first aid, took him to Mavoko police station,
but this time,
where he locked him up
because
in the cells for 3 days before charging him in Mavoko local with several criminal charges. That was the beginning of a prolonged and sustained harassment against the deceased Mwenda until out of sheer fear for his life, he approached International Justice Mission, that is IJM,
is because of the infrastructure.
And Independent Police Oversight Authority, that is IFOA, for help,
and even if you
and he got help.
It may not come to the standard that is required to host a world championship. So to look at 2027, there are 2 challenges here. One is the infrastructure. Secondly, we have got a little bit of a problem with doping matters now. We had better fight doping and come out of it as opposed to asking to host a world championship in 2027. So my thinking, and us in the executive committee, is that we are looking at 2029, and we are going to apply for 2029 to host the World Championships in Kenya. So that is our plan, and that is what it is. Now about the application.
The aim, of course, was to destroy evidence by destroying the complainant, which was not only drastic but draconian and an extreme action to take. For the second accused, he stood by his colleague, the first accused, and stuck with him in every step on the material day. The judgment speaks for itself in this regard. He did not have any personal vendetta against any of the deceased, However, he played the critical roles of abducting and holding the deceased at his police station or police post, where he was the senior officer in charge of duty. Now, for the third accused, her role was to keep the deceased persons at the police post, where she was the sentry and report officer, all the way until the time that the deceased persons were removed from the post and taken away to be murdered. I have been asked to consider that she was the youngest and the most junior in the group, and even though not requested, I've also considered that she was the only lady in the group as well. Now, being a police officer with firm, stringent pecking order system, and being junior has significance in the need for discipline and order in the force. That discipline and order cannot include aiding, abetting, and enabling crime, and eventually concealing and denying any knowledge or involvement in it. Had she been candid at any stage of the investigations or the trial, which could have been it could have been a factor that could serve as a positive extenuating circumstance in mitigation. I noted also that even in the mitigation, by her counsel on her behalf, she denies playing any role in the matter. However, to her credit, she was candid to the police probation officer and admits negligence in her place of work on the material day that was facilitative in nature. She played a role which is not peripheral, as Mr. Keegan suggested. For the fifth accused, he made a confession to the police, which I believe helped immensely in the investigation. It was his confession that shaped the investigations. His defense under oath was a further confession of his role in the whole murder. I noted the variations in his confession to the police and his confessions in his defense. He did not color anything white that was black. Now, I have carefully considered the mitigation of each of the accused persons as given orally and in writing, and part of which I have summarized in this ruling. I have also considered the various reports that were filed, the probation reports, medical report, the victim impact reports, as well as the certificates of the various courses undertaken by the accused persons during their incarceration. I have also considered the circumstances of this case, the meticulous planning, implementation, and the brutal execution of the deceased. To say the least, this was a most foul murder, an execution that was most heinous. I find that the most suitable sentence for each of the accused persons is as follows. The first accused is sentenced to death in each of the 3 counts. The death sentence in counts 2 and 3 are held in abeyance. Now, the second accused is sentenced to 30 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The third accused is sentenced to 24 years imprisonment in each of the 3 counts, with the prison terms running concurrently. The fifth accused is sentenced to 20 years imprisonment in each of the 3 counts, with the prison terms running concurrently. In computing the sentences in paragraphs 2, 3, and 4, that is in respect of the second, the third, and the fifth accused, the prison authorities to take into account the period of each of the accused have spent in custody during the pendency of this case. I also want to inform the accused persons that they have a right of appeal against both the conviction and the sentence within 14 days from today's date. So those are the orders of the court. I think I'm done here, so I want to say thank you to all those who are involved in the matter, and I wish you all the best.
My lady from the bar, I've been here for 6.5 years. It's almost whatever lifetime in the bar. So if you could grant us just 2 minutes. I know you have done.
Now, I am now funked as official, Mr. Professor.
You could just listen.
You just want me to listen.
Maybe probably before you hear him out, there were some rulings that you were to give in relation to the motor vehicles and the phones. You had asked about that last time. and there was an application that had been made by the prosecution. They had objected to our application.
Yes.
And we insist that we still want the motor vehicle and the funds that were taken from the accused persons. We would also be asking that we be furnished with the full proceedings, including the sentencing, so that we can be able to lodge an appeal, which I believe.
My lady, on our part, for the people accused, and as I think I can describe myself as a ward of the court, having been appointed to undertake this task.
You are a what of the court?
I'm an officer of the court. I'm also
you come
a ward of the court because
you come out with very interesting terminology. So what is yours?
Yes, my lady, I just wanted to, you informed me to request personally from the court that the order that had applied to Ms. Kenyori should also apply to myself with regards to representation for the few that is possible.
So, Mr. Michoke, my advocate, as you have said, what is it you are requesting? So that I can now put it in writing.
My lady, I'm just requesting. I didn't want to say the word, I was just requesting my payments. You know, so many words. Given the many years that we have undertaken this task, we thought.
I don't know. We did not make any orders in the past.
There might have been an order, but I think it was overtaken by events or not considered.
Kenneth, I know you are with me part of the time. Did you make some order about his payment? You have not made. So you want your payments as per the 30,000?
No, my lady, I was asking the court to vary that to take into account the previous order that you had given with regards to Ms. Kenyori, the previous advocate.
I'm not sure whether that is the one I'm remembering. Kenneth, did they implement it? She just got 30,000.
No, my lady, it was implemented for my colleague.
But is the one who is with the books and things. Oh, she told you?
Yes. Off the record.
On the record, I'm being told it was not.
Yes.
On the record, I'm being told it wasn't.
No, my lady, because this matter actually began before the...
No, I'm talking about Mrs. Kenyori.
Mrs. Kenyori. It was before Mr. Kenneth came into the matter. It was during Getonga's time.
No, I know that, but he was also around.
Okay.
Yes. Do you know about Mrs. Kenyori? With a certainty. Okay.
But then in that case, you can have both payments paid in kind for me and for Ms. Kenyori.
No, you're not representing her. Yes.
If I may, on behalf of the third accused.
I don't know your name for the record. Sorry? Oh, yeah, the lady who has been coming.
Yes, my lady.
Yes.
Calling you for my learned senior, Mr. Katma. On behalf of the third accused, we pray that her mobile phone to be released. And for purposes of the appeal, my lady will pray for a certified copy of the judgment and the sentencing.
Anything else?
Maybe this has been 6.5 years. And once again, we want to thank you and the entire judiciary. We want to thank you and the entire judiciary. So many judicial officers have been very helpful in this process. The law has been developed in some areas, important areas like victim representation. The family have been steadfast, and here today they are here in following up on the course of justice. The ODPP must be appreciated, Office of the EPP. They did an excellent job. It's led by my former classmate, Mr. Nicholas Mtuku, and his group, and the entire team. We thank our colleagues for such. We also thank our colleagues for all the, especially Defense Council, that is, and LSK, led by the President and currently by the President. Eric Ewuli's been so many presidencies, and now currently led by President Eric Ewuli and Vice President Warren, and members of LSK, who are very supportive with research and about this. And International Justice Mission, who have been led by Senior Counsel, for example. And its investigative officers, this was a complex matter. Both your judgment, sentencing judgment, and sentencing, this was very complex, very sophisticated criminal syndicate or criminal enterprise. The DC and the security officers need to be thanked for making sure that all was done. The entire process, investigations, arrests, and unveiling evidence, etc. Testimonies, etc. The media have been as objective as they can be, and that has really objective and have helped foreground this matter for all these 6 years at the national level and even internationally. And that has helped a lot in securing the services for the victims of their families. Of course, there has been the Witness Protection Agency, which played a very important role in a matter that involved very sophisticated criminal activity. So we just want to thank you, and we are also, in the course of this trial, 6.5 years, the Lord so increased us to go to the Court of Appeal. And while we will be missing you in the post High Court, we are happy for you, and we are happy that the Court of Appeal will be richer in the development of criminal justice. That's a very important addition to the Court of Appeal, the bench on criminal justice.
I appreciate your view that.
I stopped there by really.
Anyway,
Thank you so much. We have really learned a lot from you. That's what I'm also saying. We have really learned a lot from you in the course of, and in this case. Thank you so much.
Okay. Am I shutting out anybody?
The DPP himself.
I think our friend spoke for all the as well.
You know, I should have your proper title, which I have not mastered. Your title, official.
My title is Chief State Counsel.
No, that is Chief State Counsel.
Yes, my current designation.
No, I'm talking about in this matter, you are not a Chief State Counsel.
Gazetted as a public prosecutor.
What is your rank, Mr. Mutuko? What was your rank? Let me put it that way. Yes.
I was a deputy DPP.
Yeah.
And when the matter was proceeded, I was deployed to the Ministry of Foreign Affairs, and then I was designated to Chief State Council.
Yes.
But then the DPP gazetted me specifically to prosecute, continue prosecuting the matter. I think I shared the gazette notice to the court. It is on the file, I'll furnish it.
Okay.
Yes. So what I need to say is that Ben Sian has represented the state there in his pronouncement. Safe to say that we were expecting a ruling on the motor vehicle that belonged to the first accused. But as regards the forms, that belonged to the accused person. And really, once the order comes, it can only be served upon the DCI and they will deal with it. We had actually made a lot of presentations about those items which belong to the accused person, and they were not part of the evidence. That's all I need.
As I hand over to the President, Mr. Ongaro has been very, very helpful in this case.
Professor, you seem to be taking charge of my court.
I have retired.
Already that happens when you've been around for a while, as Mr. Sianya has been and produced a number of students. Gratitude to the court in the handling of this matter. Already we do know that it has been 6 long years. 6 years waiting for justice in this matter. There are so many lessons that we have learned from this trial, and we hope that in the future we will be able to determine our criminal cases in a somewhat more efficient manner, that we will not have to wait 6 years for the determination of case of this nature, considering that this was a direct affront on the administration of justice. And I know that I speak for the victims because they've agonized for quite a while. That said, my lady, I want to, on behalf of the Law Society, really place our gratitude on record for the council holding brief for the victims and the council representing the Law Society. So they have exercised their brief in the most diligent manner, and the society owes them a huge debt of gratitude. And we are really grateful in the manner in which they discharged themselves before this court. Already we are also grateful to all the advocates for the defense. winner in this matter is the rule of law and the administration. Is one that is going to shape jurisprudence and has enabled the growth of not just victim representation, but we've learned significant lessons in witness protection, the use of technology to detect and prosecute crimes. And so I know that all the advocates who are involved in this matter are proud to have participated in this proceedings. And as we end this matter, we recognize and remember the words that are set forth in our national anthem, that justice be our shield and defender. My dear, thank you for giving me this opportunity to address you.
I've just received an instruction from my client. Might indulge me.
Is it where I'm thanked as official?
Yes, my lady, but...
So I listen without writing.
My lady, this one has to be written, unfortunately.
Okay, let me decide whether to write or not.
Yes. My lady, it's with regard to the circumstances of this case. You are aware that the field accused has always been held at Naivasha prison for certain security reasons. He has asked me to ask the court to make an order that his committal should remain at Naivasha, where his security has been always secure throughout the proceedings. And
I think that one is, that I'm truly, not just thanked as official, I have nothing to do with it.
With that, we understand that, my lady, but it's just in the...
And I'm sure there's something you can do.
In this case.
There's something you can do about it yourself as his counsel.
Yes, my lady, but...
And you can speak to Mr. Motuko.
I'll do that.
Chief Counsel,
yes.
Chief State Counsel. You know the age is in.
Yes, my lady, I shall see him and have a cipher with him.
So, am I now allowed to adjourn this court? Thank you very much. Court is adjourned.
But that said and done, we know that there have been several cases of ongoing police brutality. We know that there are so many cases of enforced disappearance and extrajudicial killings. And this is just but a small win in a very, very big fight to ensure accountability in use of police powers. And so as a law society, we would be taking further action to ensure that the well-documented cases with regards to police brutality, extrajudicial killings, and enforced disappearance are dealt with. Because if we do not deal with those issues, the murder of Willie Kimani would have gone unaccounted, were it not for the determined and diligent efforts of the various stakeholders. The perpetrators of that heinous crime, who have today been sentenced to accordingly, would have gotten away. And so we need to be vigilant. We need to keep this fire burning
and we will work with all the other relevant stakeholders to ensure that we bring to an end the culture of extrajudicial killings. To the family, I am sure that this decision, even though it has come 6 years, brings closure to the brutal murder of the 3 victims. And we know wherever Willie Kimani is smiling from heaven, because the work which he began in terms of seeking police accountability has been finalized today by this decision. Thank you.
Summarize the statement so that we can share with us, we can have an elaborate one.
Thank you very much, ladies and gentlemen of the press, the family of the deceased, the victims of the suspects who are now sentenced, and we now have them placed in custody under the sentences that have been given. Good morning. I will read a statement on behalf of the Police Reforms Working Group. That is an alliance of 20 human rights and governance organizations this morning. And I will just be brief because I believe we have all been sitting waiting for this moment. Today we close the chapter on one of the most heinous murders of our decade. The murders of Lawyer Willie Kimani, his client Josephat Mwenda, their driver Joseph Mwiruri, brought to the fore the dark abyss of police criminality in Kenya. With their sentencing today, we can sigh a sense of relief. We can feel a sense of justice. There may be no joy in this moment because we have lost 3 human beings and it has taken 6.5 years for this case to be concluded, but there is a sense of justice. As the Police Reforms Working Group, we would have liked to have seen stronger sentences, particularly life imprisonment, because we feel that the threshold of responsibility for state officers has to be much higher than that for citizens. That you cannot use state resources, you cannot use state officers, you cannot use the shield that you and the oath that you have given as a police officer to murder people in the way that these 3 human beings were dispatched. So as the Police Reforms Working Group, we would like to start by saying that this is a great start in terms of building a culture of police accountability. But as the President of the Law Society has said, there are many other cases. Next week, we will see the case of Police Constable Ahmed Rashid. We have also the case of former OCS Yunus. There are a number of cases in addition to those that are coming before our courts. And I think what we have to say is that the tolerance for what we used to call rogue officers, that tolerance is now over. But the intolerance that we need to have is with a system. It is not enough to talk about a few bad apples. We have to talk about the tree, the soil, the water, the air that gave rise to the apples that have taken the lives while as police officers. So we have to look at systemic change as well. So this message is also to the Interior Ministry. It is also to the Office of the President. We can start by acknowledging and congratulating His Excellency the President for disbanding the Special Service Unit. We can continue by demanding for prosecutions for those that were responsible for 37 people that were found floating down God's River in Yala. We can also demand a number of changes. And I think one of the things that we have to say is that when the state has political will, the cases of extrajudicial killings go down. In the last 1 year, we have seen a 30% drop in the cases of extrajudicial killings and in the case of enforced disappearances. Why has this happened? It has happened because, first of all, the press have continued to follow these cases. So we thank you for doing that. It is also the case that investigators, prosecutors and oversight officers in the Independent Policing Oversight Authority, that vigilance that is there continues to make it impossible for police officers to think rationally that they can abuse the rights of Kenyans and still come back to work the next day. So I think this judgment is important in that regard. 3 other quick policy decisions that are required. We have to demand at this point that the Attorney General and the Parliament effectively and fully implement the National Coroner Service Act of 2017. That act and the Prevention of Torture Act came into being 1 year after the Mavoko 3 were killed, and it is a shame that we have not seen these two pieces of legislation enacted. The new government of His Excellency the President William Ruto has an opportunity to show leadership by essentially implementing these two acts. We also need to see the government of Kenya criminalize enforced disappearances and extrajudicial killings by ratifying without any reservations the International Convention for the Protection of All Persons from Enforced Disappearances. And lastly, we have to see greater vigilance and greater interruption of those parts of the police service that have come to serve not the public, but to serve themselves and to act in a manner that disgraces their uniform, that frightens a nation, and does not increase the possibility of safety and dignity for all. To the family of the 3 suspects to the victims, on behalf of the Police Reforms Working Group, allow us to convey our sympathy, our empathy, and our solidarity, not just over the last 6.5 years, but for the rest of our lives. What you have gone through, no family in this republic should go through this. You are brave, you are courageous, and you have stood by your loved ones right to this moment. And I think we have to acknowledge you as a nation for really being that parent, that brother, that cousin that essentially stood with the victims until the end. I thank you very much.
So we'll start with Hannah, who is Willie's wife. Tuambie nahisi vipi, imekuwa muda sasa, imekuwa miaka kama 6 along the way mlikuwa mmekosa imani kwamba haki itatendeka, lakini leo hii mtupe hisia zenu.
My name is Hannah Wanjiko Gitweria, wife of the late Lawyer Willie Kimani, and today we are very happy that justice has been served. And at least now Willie can rest in peace. And along the way we had lost hope. We thought it would never happen. But we really thank God because our God is a God of justice. Yes.
Leo ukija hapa ulikuwa unatarajia yapi yatatendeka, labda kesi itasogeshwa bado mbele, au ulikuwa unatarajia nini ukija?
Actually, I was very hopeful that we are going to get justice. I had no doubt that they had committed the said crime. Yes.
And how are the kids?
The kids are doing well. They are in school. Castro Kinoje is in grade 5 and Patterson Gitweria is in grade 2, but they are doing well. Yes, thank you.
Sasa hivi wameanza kuelewa maneno, walikuwa wanajua kwamba leo ni siku ambayo hukumu itatolewa.
No, I try to explain to them, but you know, them being kids, you just let them be kids. But for Castro has memory of the dad, but Patterson does not have the memory of dad because in 2016 he was 9 months old. Yes.
Labda utakaporudi kwenda kuwachukua kutoka shuleni. Taarifa gani utawapa?
I will try and explain to them in a language they will be able to understand. Yes. Yeah.
Thank you.
Thank you.
Rebecca, utasema tu jina lako pia, sababu kila mtu anajua, alafu ongeze sauti kidogo tuambie. Ongea kwanza kwa jina ndio na ongea na sauti utuambie.
Jina naitwa Rebeka Wanja Mwendwa. Mimi nilikuwa bibi ya Mwenda.
Ana college. Msikirie huyo. Mwenye tere.
Kwa majina naitwa Stella Grace Kimani, sister to Joseph Muiruri mwenye alikuwa taxi driver.
Imekuaje tu? Tunajua imechukua muda na hivi sasa tunapata haki. Tunahisi vipi? Kama haki.
Kwanza tunashukuru Mungu sana kwa siku ya leo. Ametuwezesha after 7 years tumepata justice. Okay, we had confidence with just receipt from the word go. Although haijakuwa rahisi, it was very tough, lakini Mungu ametushindania. So tunasikia vizuri, tunasikia okay, these are my brothers, na tunasikia tuko relieved. Hata tumesema leo mtu anasikia vizuri tu, amerelax, kila kitu imeenda vizuri, we thank God.
Angalia hivi face, yes, hapo mwanzo kwa majina.
Naitwa Mugambi na mimi Edward Mugambi. Mimi ni brother ya Mwenda. Mimi nimefurahia na nimefurahishwa na uamuzi wa koti. Hiyo tumengojea miaka mingi, kama miaka 7 hivi. Mimi nilikuwa nimesikia vibaya sana kwa ndugu yangu, lakini mimi nimefurahia na hiyo uamuzi wa koti, na resiti amefanya kitu ya maana sana, na mimi nashukuru Mungu. Asanteni.
Okay. I think we can close with the International Justice Mission Country Director, Lawyer Willie works. Please.
Director.
My name is Benson Shamala. I serve as the Country Director for International Justice Mission, where Willie used to work. And today is so encouraging to see that we have come to the end of this long and protracted case. As you have heard, we have taken close to 7 years following up on this particular case. We have made 185 court appearances in those particular close to 7 years. And today we are happy that justice has been served at last. Of course, we would have loved to have a higher sentence for the second, third, and the fifth accused. But we believe that this sends a strong message to the people, especially the police officers who have been given the mandate to protect Kenyans, and they turn those particular mandates to violate the other Kenyans. IJM is part of the Police Reform Working Group, and we are happy to see that today justice has been served. We know that there are so many other cases of police killings, so we believe that this will start a process whereby we can have accountability in our criminal justice system, especially for the police. I want to thank all the people that have been involved in this particular case, the media, who have kept this particular case in the limelight for all these years. I want also to thank the investigative officers, because they did a fantastic job to unravel the mysteries that were surrounded in this particular case. As we've heard from Lady Justice Lesit, this was a case that was well orchestrated, well planned, and well executed. We could have gone without any trace, but but the police investigating officers did a great job in unearthing the mysteries around this case and bringing the culprit to book. I want also to thank the prosecution side and also the lawyers who are for the victims and also LSK. They have stood along with us, International Justice Mission, to follow up on this particular case, pushing it. This case had a lot of turns and twists, but eventually we have seen justice. I also want to thank the Police Reform Working Group for standing with us all through. And more importantly, the families of the 3 victims. They have stood with this justice. They have stood their ground in following up in this particular justice. And no family, as Mr. Irungu has said, should go through this. The anguish, the agony that the family have gone through. But all along, they wanted justice. And I believe that today marks a beginning of their healing journey, that they can put this thing behind them so that they can go on with their life and get somehow a new normal. So thank you, and thank you so much.
One question by one director. Maybe in this healing process, do you have any measures that you will be keeping in touch with the family and checking on them frequently?
In the National Justice Mission, we have got a way of strengthening our criminal justice system, and one of the critical things also that we do is taking care of the families of the victim. We have worked with this particular family each and every day, and we continue working with them because we know that that journey of healing is not an easy one and it's not a short one. So our commitment is to continue working with the family, providing all the psychosocial support that they may need so that they can come to a place of healing. Of course, we know that even with this happiness that we have gotten justice, we may not have Willie, Joseph, and Josephat back. But we know we can support the family to have a new normal where they can live on now, even without them.
One last thing, mention something about the boardroom that has been dedicated in memory of Willie Kimani.
So when you come to our International Justice Mission, first of all, when it happened, it took almost 2 years to touch the seat and the desk where Willie was seated. All the things that were on his desk during that time, they remained intact for almost 2 years. And no one wanted to touch it because of the memories that we had. It was a very difficult time for International Justice Mission staff members. Somebody whom you worked with, not only as staff, but also a friend. And so in honor of him, in a small way, we have a boardroom that we have dedicated it to Willie Kimani as a memory. Not that we can forget about Willie Kimani, but to memorize him to who he was to us. And not only Willie, but also Joseph, who was very close to us, and the client that we are serving, Josephat. Thank you. Thank you.
Thank you.